Hi, hello, my name is Balqis, and I will be explaining what is LAROW and its silent features. What does LAROW stands for? LAROW stands for Land Administrator Right of Way. This land administrator can be referred to the state director, the registrar of the title, and any person required or empowered to hold an inquiry. LAROW can be divided into two, which is the public right of way and private right of way. In public right of way, it is a right given to any member of the public to use a particular route as a public passage. For example, highway, street, and public road. We refer to the case of Lee Tian-Su and Syarikat Warsaw. It was held that the state authority has the power to create either private or public right-of-way depending on the need and the circumstances. On the other hand, private right-of-way may be created by a land administrator for the benefit of the state authority or for the benefit of any individual to pass and repass a public terminal. The person for whom the right-of-way is created must be an occupier or proprietor of an alienated land. The right-of-way given to him may allow him to extend his permission to use the land to anybody to pass and repass the public terminal. Additionally, the land administrator can create LAROW either with or without the consent from the landowners, but only an application by the state authority, proprietor, or occupier of any alienated land. LAROW is governed by Section 387 until Section 396 of the National Land Code 2022. Basically, Section 387 of the National Land Code defines a public terminal as a foreshore, a river, railway station, or public road. Additionally, another example of public terminals that can be included are like rapid transit, the airport, and the port. Section 389 subsection 2 of the National Land Code, on the other hand, provides the private right-of-way created based on application by the state authority will authorize the person acting with implied and express provision of the state authority to do the following, which is the first one, to pass and repass between the reserved land and a public terminal. Number 2, to pass and repass between the forest reserve and a public terminal. And number 3, to pass and repass between the land and a public terminal for the purpose of removing rock material on that land. We have looked at the characteristic of LAROW. Now, the next question is how to apply LAROW. Well, Section 390 of the National Land Code provides that the state authority or the proprietor or occupier of any alienated land may apply to the land administrator using Form 28A for the creation of right-of-way. In granting the public right-of-way, the land administrator may refer to the report prepared by the settlement officer on the application of the public right-of-way. The report should cover the status of land, whether it is an alienated land or not, and the existing access, if any, as well as the possible damage together with the proposed cost of compensation. Wait, compensation? Hang on. Before I proceed, the next query here is, who pays for the creation of LAROW? The cost of survey, maintenance, construction, and repair is borne by the person or the state authority for whose benefit the right has been created. The right-of-way may be shared by other adjoining lands, provided that they have made independent applications to the land administrator. Section 393 subsection 2 assures that the proprietor of the burdened land shall be compensated accordingly. To make my point clear here, we can refer to the case of Kelab Renang Pulau Pinang and Pentadbir Tanah Daerah Timur Laut Pulau Pinang. So the court reiterates the principle in Section 393 subsection 1 of the National Land Codes, which that the payment of compensation to the landowner whose land was affected by the creation of LAROW is not only paid for the damage suffered, but for the use of the land as LAROW. Now, if you want to know the LAROW is expedient or inexpedient, let us see some of my friends in action.
Thank you, Balqis, for the insightful explanation. Hi everyone, I am Madam Hafiy, and together with me,
I am ALIFEE.
I'm EMERR.
I'm NAJWAN.
So, together we will explain to you the detail about the expedient and inexpedient aspect of the land administration right-of-way, and also show you guys some scenarios which our explanation can be applied to. So, first of all, a right-of-way can be considered as expedient when there is a need for a way to be granted for either public or private use. However, the reason for its creation must be with a reasonable excuse and not just by merely inconvenience. The word expedient itself means properly and reasonably. Any authority that is conferred on a public official to grant a right-of-way against a landowner for the benefit of another has to be exercised for a proper purpose and reasonably unless exceptional circumstances exist. So now, how does land administration determine a right-of-way to be expedient? So, before right-of-way may be granted, the land administration must satisfy himself that access is not otherwise reasonably available. By this, it means that the land administrator needs to first investigate whether there are no viable options of way to navigate rather than only through a landowner's property. So, it is not expedient to create a right-of-way where there is an alternative route because it goes back to the purpose of having it in the first place, which is landlocked. So, a landowner cannot simply apply for right-of-way just like with using his neighbor's land for his own convenience, but as that would be an immoral act which has restricted some parts of with the property right of another.
And even though there is an alternative route for public or even private use, the condition of the alternative route still needs to be taken into consideration, as if the route is unmaintained, full of mud, or is not suitable for a long-term use. It does not constitute to an alternative route, and therefore right-of-way can be applied for the state authority to take an action to make a suitable route for more suitable use. So now, we will look into the scenarios whereby it is expedient or not for a right-of-way to be imposed onto one's property.
I know this land, it means a lot to you. But Sri Damai right now, currently, is at a standstill. And it's not working out.
Look, I know, I understand, but that land has been my family's land and legacy for generations to come. I won't give any piece of it to any one of you.
Najwan, MA, we need to know, we are all in this together. We are Sri Damai. So please, MA, we need that land.
This has been my land now and forever. I won't give a piece of it to any one of you, whatever you bribe me with, whatever you throw at me. I'm done with this. I'll see you in court.
MA! My wife, MA, my wife died from heart attack because the ambulance arrived late to here, MA. The ambulance arrived late from the main city, MA. Don't you remember that, MA? Huh?
Wait, please, let's settle the segment. Don't be child. Sit down.
Fine. Look, maybe I did overstep my boundaries. I'll think about it.
That's fine. But you we can no longer afford delays. I feel like this project needs to be done, this road project needs to be done urgently.
Alright. Maybe I've been too focused on the past. I'll approve of this. Okay.
This is the town of Sri Damai. Meanwhile, this is the main city where the hospital is located. To get to the hospital in the main city, people of Sri Damai need to go through here, through here, and here just to reach the hospital. As you can see here, if the right-of-way can be granted from Sri Damai to the main city through the land of EMERR here, it will definitely shorten the length of the route to the hospital. Through this proposed right-of-way, the length and distance for the people to go to the main city take only 15 minutes, while the actual road can take up to 1 hour and 15 minutes. Now we can see how the proposed right-of-way here is expedient for the benefits of the community.
The hospital is too far. I wonder if I can find a shorter route. Maybe I can apply for a private right-of-way.
So, when we asked what's your reasoning for...
To be honest, I just found out that there is a shorter route to the hospital, which I am a doctor there, and I think it is a necessity for me to arrive there early, as because the doctors are always on call, right? So I think I want to apply for a private right-of-way. Can I?
Okay. You can fill out this application form first, and then talk about it.
Okay, sir. So, if I may know, can I just apply this form and without, for me to contact the landowner himself? Because I think he is hesitant in giving me a passage through his property. I think so. So do you think it's possible for it?
Okay, I'll try to investigate first, and then I'll contact you later on if whether or not I should, contact the landowner or not regarding the situation.
Yes, sir.
Sure. Very good.
Okay.
Okay. Thank you, sir.
Thank you so much.
Hey, hey, hey!
Oh,
What
yes, sir.
are you doing here?
Okay. Oh, sorry.
Huh?
Let me. I'm here to investigate because yesterday there was an applicant that applied, for a right of way for him to use this route to go to the hospital, and I'll just see how the route is.
The route?
Yeah.
This route?
Yeah.
Hey, this is my land, you know.
Well, yeah, I know.
Hey, you know, the route to hospital is not that different between that and here, you know. The difference, I think, only 1 kilometer. Why he wants to use my land? Hey,
Well, wasn't there anybody else that came?
hey,
Before-
not even my child can use my land. Hey, this is my land, you know. I have my right.
Okay.
Hey, yesterday, there was a man that want to use this, my land, as a route.
I think that was the person who applied. Yeah. So if you want to settle this out, you want to meet the person who applied, and then
Who?
We'll go and see.
What?
Okay. So, sir, I want to apologize beforehand because we find that after you applied yesterday and we did conduct the investigation, we saw the area, we saw the alternative route that you proposed, and we find it to be inexpedient because reasoning such as you can use other routes to reach, the destination that you want to go to, and it's just a difference of 1 kilometer. If you want to arrive there early, then step out of the house earlier in the morning.
I see your reasonings, but I think even though I can't apply for the private right of way, but don't you think I can apply for a public right of way? Because as I'm not the only one who is going to use this road, because if you open this, the public also can use it too.
Okay.
Hey, public right of way. Hey, I never let people get near my land, you know. Not even my child, not even my dead wife can get near my land. Who are you? Huh? Who are you
Oh.
to use my land?
Okay. So if you want to look at public, there must be dedication. In this case, the landowner himself never allowed anybody, any individual, to enter his land to go to the hospital. So we find it to be the same case because for public there's no dedication. So you cannot grant that even through public interest. Yeah.
Too bad then. Well, I don't even care about this.
Goodbye.